look. We're joined now in studio by Rachel Litchman. She's a criminal defense lawyer and here to give us her reaction to this. So let's talk about this case. Really, the issue of consent was key here. Tell me about that, because some legal minds are saying that this really came down to he said, she said, and there was not reasonable doubt.
Yeah, so exactly what you said. The case in sexual assault is usually almost always that he said, she said type of thing, right? So the complainant says one thing, that it was not consensual, and then we know that Mr. Hogarth testified and said it was something else, that it was consensual, right? Mm-hmm. So it really comes down to who was believed by the jury. And in this case, there were other people that testified as well, and it seems like it was a split between the two, right? So again, it's which side does the jury fall on, and who does the jury find credible and believable in the absence of anything extra.
Okay, so what does this say about the job that the prosecutors did, really? Because, there was a similar case, as Sarah was just talking about, where he was found guilty on one of the charges. Yes.
And that was ruled that it was not admissible to be spoken about during this trial because it was ruled to be prior discreditable conduct. And really what that comes down to, those rulings come down to, is, okay, what is the prejudicial effect of this? And what weight does it have in trying to help the jury come to a decision? And in this case, it's extremely prejudicial, right? Because the jury could use this propensity reasoning, saying, oh, if he was found guilty before, it could be possible that he would do this again. And really that it doesn't actually help make a decision in this case, if it happened in this case. So it is very dangerous to expose that to them. But keep in mind, this is a very high profile person, right? So the jury was probably aware of what had happened beforehand.
So, when we talk about the jury, 9 women, 3 men on the jury, how key is jury selection here?
Well, the thing is that currently the laws in Ontario don't really allow much room for defense or prosecutors to do much by way of jury selection. Really, there's only going to be purposeful questions asked to them that pertain to the case, if any, but there's no such thing anymore as defense or Crown / prosecutor making any kind of objections and saying, well, we don't want this juror. That's not available anymore in Ontario. So there's not much that either side can do when selecting the jury.
You mentioned, his fame earlier. Do you think that could potentially be, could have been a factor? And how when it comes to the jury, do you ensure that isn't influencing folks that are on the jury?
Yeah, so I think for sure fame is a factor, right? But I think when people think about it, they don't appreciate that it's a double-edged sword, right? So it could be used to his advantage, people thinking, oh, he's so cool, he's a rock star, but it could also be used against him, right? People thinking, well, look at everything that's been happening in Hollywood lately, look at these men that just totally disrespect women, so it could be used against him as well, right? And the way to kind of deal with that issue of whether there is a bias towards him because of his fame would be through a challenge for cause when the jury is being selected. I don't know in this case if there was one or not. That would have to have been dealt with in a motion before the trial started. I didn't hear anything about it, so I'm assuming that didn't exist.
Did it surprise you how quickly the jury came to their verdict?
It usually happens when they already have an idea in their heads of where they're going. They'll give the verdict very quickly, right? Because there's not much for them to deliberate over. So obviously, hearing the evidence, while they were hearing it, they were probably already making assumptions about her testimony when she was testifying, and then also making assumptions about his testimony when he was testifying.
Most surprising thing to you when it comes to this particular case?
There's not anything surprising to me as a defense lawyer. I think that for other people it's surprising, and I think that maybe it's surprising because what usually the populace thinks is when someone is charged, they are guilty. I don't look at it like that, right? I'm a defense lawyer, so I look at it, well, he's presumed innocent until proven guilty, right? So it's not a shock to me. They both got a chance to say what they wanted, and the jury decided that his evidence was more credible.
And it's not surprising to you at all that, you have a very similar case where the outcome was very different?
No.
No?
Because there could be scenarios. First of all, he's appealing that, right? I think that he was recently shut down on that, but he's appealing that. But I think, it's not it can be either side of the spectrum, right? When you're dealing with people in a position of fame, there's two ways that it can go. There could be people that are just targeting him because of his fame and for money. And then there could be he's been disrespecting people and using people and abusing his power in that position as someone in a place of fame, right? So the fact that there's all these allegations, no, it's not surprising. Again, it could be either way. I'm not saying he is guilty or he's innocent. I think that when you're in that position, when you have that money, when you have that fame, it can go either way. And I think that, you know, juries are a finicky thing, right? And you never know how they're going to see you. You never know how they're going to see the complainant. In the case where he was found guilty, obviously the complainant was more compelling, right? Just because maybe that did happen, maybe that didn't happen. I don't know. I was never there.
Right.
But just because he's found guilty of one thing, I don't think he's guilty of everything.
Is there any recourse for her now, or is this done?
It's not so much about her. It's more about the appeal process. It's really hard to appeal sex assault decisions, especially when it comes to a jury, because it's not a judge that made a decision and wrote the decision and said why they found that. So to appeal this, what has to be done is that there has to be a problem with the judge's charge to the jury, and a higher level court has to find that there was a problem with what the judge said to the jury.
So it's possible, but the bar is very high.
Yes, and she can also decide to go to civil court and try and sue him in civil court, because there is a different standard there. It's not proof beyond a reasonable doubt. It's a balance of probability test. He's not going to be found guilty criminally, but she can come after him for damages if she suffered physical or mental issues because of this. So she can go after him in civil court.
Okay, Rachel, appreciate you coming to studio on
Thank
short
you.
notice on the breaking news. That is Rachel Lichman, a criminal defense attorney, joining us here in studio. Well, police in Ontario say that a 30-year-old woman has been arrested and charged in connection with a murder spree that spanned 3